Okay, let's dive right into this explainer. We're looking at a genuinely fascinating, century-spanning property dispute. It's got everything: a Hindu deity, a fraudulent manager, and a massive legal loophole. We're talking about a real, documented legal battle out in Madhya Pradesh that really forces us to question the fundamentals of ownership, trust, and frankly, the ticking clock of our justice system. To make sense of all this, we've broken down our analysis into 6 quick parts. First, the temple and the servant. Second, the anatomy of a legal fraud. Third, the quick sale. Fourth, the 22-year delay. Fifth, asking if the suit is time-barred. And finally, the ultimate legal principle.
So part 1, the temple and the servant.
Right off the bat, we have to ask, can a manager sue their own employer and just steal 19 acres of land? It's a shocking question, but it sits right at the very heart of the case we're unpacking today. I mean, imagine an employee taking the company house they live in, secretly suing their employer, and then selling the house to a total stranger. Sounds completely impossible, right? Well, through a wild series of legal maneuvers and government no-shows, that is exactly what went down.
Now, under the law, the Hindu temple itself, specifically the deity, Murti Sri Ramji Mandir, is the actual legal owner of this 19-acre plot in Mangalia village. You see, a deity is treated as a legal person, kind of like a corporation. But since a stone idol obviously can't walk into a courtroom or manage a farm, a government guardian is appointed to protect its assets. In this case, that duty fell to the collector of Indore.
Enter the antagonist of our story, Babu Lal. He's the son, or perhaps grandson, of the original temple manager Kishan Das. Babu Lal is the guy who orchestrated this whole heist. He basically took advantage of his family's long-standing position at the temple to wrongfully claim the land as his own personal property.
To see how he pulled this off, we really need to look at the difference between personal property and a service grant. Remember that company house analogy? When the original manager, Kishan Das, was given those 19 acres, it was an inam, a land grant. But crucially, it was absolutely not a personal gift for him to sell. It was provided strictly so he could sustain himself while performing his daily temple duties.
And that brings us to a really vital distinction about Kishan Das. According to an inquiry report way back in 1929, the land was given to him specifically for puja evam prabandh, which means worship and management. He was just a service holder for the temple. Legally speaking, he was completely barred from treating this land as his own real estate.
Let's move on to part 2, anatomy of a legal fraud.
So how did a service worker actually pull this off? Well, a massive loophole opened up with a 1959 land reform law called the Madhya Pradesh Land Revenue Code. This law granted Bhumi Swami, or legal ownership status, to certain Inam landholders. Babu Lal jumped on this and wrongfully claimed the law made him the personal owner. The temple obviously argued that since the grant was for temple service, the deity remained the absolute owner. But Babu Lal saw the confusion and decided to exploit it.
Look at this timeline, because it builds into an incredible conflict of interest. In 1983, Babu Lal filed a civil suit claiming ownership. The crazy part? He was listed as the plaintiff while simultaneously acting as the temple's manager. He literally sued his own temple. And to make matters worse, the collector of Indore, the government guardian who was supposed to defend the temple, just didn't show up to court. The judge only heard one side of the story. So in July 1999, an ex parte or one-sided decree was passed. Babu Lal was wrongfully declared the owner by default.
Which brings us to part 3, the quick sale.
Once Babu Lal had that court victory in his back pocket, he wasted absolutely no time. By November 1989, literally just months after the decree, he sold a huge chunk of that stolen temple land to third-party buyers for 1,244,240 rupees. He quickly cashed out on property that was never his to sell in the first place.
But eventually, the government woke up and fought back in the revenue courts, which are the folks who manage land records. After a bunch of challenges by the collector, a local land officer finally laid down the law in January 1994. They passed a final order declaring that the lands absolutely belonged to the deity, and they canceled the new buyer's entries in the official land records. Now, part 4, the 22-year delay.
You'd really think the story ends right there, right? The temple gets its rights secured, end of story. But no, there is a massive, totally unexplained gap in time that creates the legal drama we're seeing today. Despite winning in the revenue court in 1994, The temple and its government guardian waited an astonishing 22 years from the date of that original 1989 decree before finally filing a proper civil suit in May 2011. They finally went to civil court demanding the official cancellation of the 1989 decree and those registered sale deeds.
This huge gap leads perfectly into Part 5. Is the suit time-barred?
This is the exact dispute sitting before the High Court right now. The law places strict limits on how long you can wait before you sue. The land buyers are arguing that this is a private temple. If it's private, Article 59 applies, which gives you a strict 3-year window to file a lawsuit. By their math, the clock ran out decades ago, making the 2011 suit completely invalid. But on the flip side, the trial court recently ruled in 2024 that because the collector manages the temple, it essentially counts as a government suit. Under Article 112, the government gets 30 years to file. The buyers have now challenged this, setting up a massive legal showdown over a ticking clock.
Finally, Part 6. The ultimate legal principle. Before we wrap up, we have to ground this case in fundamental Hindu property law. Ultimately, Babulal's family acted as sebayats. A sebayat is a hereditary manager or priest. Yes, they have the right to manage the property and use its income for upkeep, but they hold the property strictly in a fiduciary capacity. They're essentially trustees for the idol. They are entirely, 100% legally barred from treating the land as their own. And this isn't just theory. It's heavily reinforced by Supreme Court precedent, specifically in the landmark Ayodhya judgment. The Supreme Court laid it out clearly. An idol is basically in the position of an infant. It can only act through its manager. But a manager can never, ever exploit temple property for personal gain against the deity's interests. Babural suing his own temple was a massive, direct violation of this fiduciary duty.
So, as we wrap up this explainer, I want to leave you with a question. When you're forced to weigh a documented, undeniable fraud by a trusted servant against a massive 22-year government delay, what do you do? Would you uphold the 30-year government rule just to undo the heist, or would you apply the strict 3-year private limit and let the fraudulent sale stand? It's an absolutely fascinating question of justice versus procedural deadlines, and it's one the High Court is going to have to answer very soon.